Welcome to Legally Speaking. I'm Sonia Brown.
And I'm Kenya Johnson. Legally Speaking is brought to you by the Georgia Association of Black Women Attorneys, GABWA.
GABWA is a voluntary bar association that serves as an advocate for women and children and seeks to empower our community. Remember, this show is not intended to give legal advice. So if you have a legal issue or concern, it is always best to consult an attorney.
Today's topic is personal injury claims. Personal injuries come in various forms: slip and fall accidents, automobile accidents, and medical malpractice. Today we're joined by two attorneys that specialize in the area of personal injury claims. According to the statistics, 1,720 Georgia drivers are involved in collisions every day. That's over 70 automobile accidents per hour. What that also means is that as a Georgia driver, you're likely to be in an automobile collision at least once every 10 years.
Our first guest today specializes in handling automobile accident cases. When we return to Legally Speaking, we'll talk to attorney Saundra Davis.
Everything you need to know about automobile accidents and more when we return on Legally Speaking. Stay tuned.
Please remember that this show is not intended to give legal advice. So if you have a legal issue or concern, it is always important and best for you to contact an attorney.
Welcome back to Legally Speaking. Now we're joined by attorney Saundra Davis. Attorney Davis has been practicing law in the area of personal injury for 18 years, and she dedicates her practice to representing those that have been injured. Welcome to Legally Speaking.
Thank you so much. Glad to be here.
Attorney Davis, let's start at the very beginning. I'm in an auto collision. What are the first things that I should do if I'm ever involved in an accident?
If you're involved in an accident, the first thing to do is get out of harm's way. Sometimes your car is in the middle of the road. Get it over to the side. Next, you'll assess your own bodily injuries. If you're injured and you have access to a phone, try and get to the hospital as soon as possible. Also, you'd want to call the police to get things documented in terms of where that collision occurred, the weather conditions, the street, what other parties were involved. So we need documentation from the police and documentation from a medical provider, or one or more.
So for those viewers that are tempted to just exchange information with the other driver and deal with it later, what are some of the disadvantages of handling it on your own?
That's going to put them in a tough spot for various reasons. Well, you know, if it's a property damage claim and you just want a bumper scratch fixed, you can probably handle it directly with the person that hit you. In most cases, though, if you're injured, and we're talking about bodily injury and personal injury here, you'd want to have, the police document it for you, as opposed to them, who you don't know, handing you a piece of paper with a name that may or may not be theirs, a phone number that may or may not work, and an insurance company that may not hold a policy for them. Sometimes there are policies with that company, but they're expired, or it's not a person who should have been driving that car, so they're going to deny you coverage.
Okay. And for those that have been injured on the scene, what are the advantages or disadvantages to going directly to the hospital or seeking treatment soon after versus waiting some significant period of time?
The advantage of getting to a hospital or seeking treatment early is that you're going to have, again, medical documentation. Most of us are not medical professionals, and even if we are medical professionals, we still have to have that documentation to justify the claim that we'll be bringing later. You may be injured and go home, which is fine because you may have adrenaline pumping or just need to get home and rest. But the next day, you're probably going to wake up pretty sore. Again, you're going to need medical documentation. I suggest people go to the emergency room and get checked out. A disadvantage of waiting is it's going to affect your claim. If you wait 3 weeks to go to your family care physician, your primary care physician, or the emergency room, however you're going to get that medical documentation and you wait, it looks less likely that you have a serious injury.
Okay. And as soon as the accident occurs, the telephone starts ringing from the insurance companies. What are some of the benefits of hiring an attorney versus handling your personal injury claim on your own directly with the insurance company?
There are almost all benefits to hiring an attorney to handle that for you, because attorneys who practice in this area, such as my firm, we're used to handling this. This is our job. This is what we do. When you're trying to handle it on your own with the insurance company, you're dealing with a claim representative who knows the ropes, and you don't. So now you're trying to figure out an area of law that you don't know. You're dealing with your own frustrations and bodily injuries, trying to get your body well, and it's too frustrating. There's so much that goes into it. You don't know what to ask for in terms of damages. You'll probably miss out on something you're entitled to when you try and handle it on your own.
No, well, we certainly wouldn't want to do that.
No.
Well, once an injured party has been convinced to hire an attorney, tell us a little bit about the fees related to attorneys and personal injury claims. How do attorneys and law firms get paid?
Okay. Most fees for auto accidents and auto collisions are contingency fees. Those fees basically say, when I get paid, me getting paid is contingent upon you recovering something. So of course, attorneys want more serious injuries and more damages, you know, a more serious case. If you have a case and you recover nothing, a third, which is the usual contingency fee amount, a third of zero is going to be zero. So the attorney fee would be zero. However, there are fees and there are expenses. So there may be expenses incurred as well.
Well, tell us about some of the expenses that are incurred with the claims.
Expenses incurred in claims would be accident reconstructionists, putting back together how the collision occurred, ordering medical records, police reports. So they're just things that go into it to even get your claim ready to present to a claim rep for a claim or to file a lawsuit.
Now, we've spoken a lot about insurance companies. What do you do if you have been injured or has a collision with someone that has no insurance?
That unfortunately happens quite frequently in Georgia. If they have no insurance, hopefully you have insurance, and not just liability insurance, but uninsured motorist insurance. We call it uninsured motorist insurance. And that allows you to file a claim against your own insurance company and say, hey, it wasn't my fault, but I've been in a collision, I've paid you the premiums to cover this scenario, and now I'm filing a claim against you, my own insurance company.
Attorney Davis, if you have to file a claim against your own insurance company under your uninsured motorist coverage, will your premiums go up?
No. coverage or uninsured motorist coverage, it's a benefit that you pay for on your own auto. It expects and anticipates the scenario that somebody has hit you and doesn't have coverage. But you still need to get your body right. You still need to submit your medical documentation to support your claim. It's just that you're going to file your claim under your own policy, and your premiums will not go up because you're not at fault.
Well, to piggyback off of that, if you are not at fault, do you still have to report your collision to your own insurance company, even though the other party has insurance?
Yes, it's a great idea, and I would recommend it in every situation. You may not need to file an uninsured motorist claim or an underinsured motorist claim, but if you do encounter a situation where someone doesn't have coverage or doesn't have enough coverage to cover the damages that they've caused in the collision, there may be a notice requirement, and most times there is a notice requirement in your own policy that says if you don't tell us about it soon enough, we're not going to cover you.
Now, say if I'm struck in a collision and the other party is cited, how important is it for me to go to court and follow through with that process on their citation?
It's important. Some cities will actually dismiss the citation if the person who was hit doesn't come. Because when an officer issues a citation, they're not at the scene. They kind of assess what happened after the fact. If the person who caused the collision or is alleged to have caused the collision pleads not guilty, then who else is going to put in the rest of the facts other than the person who will have to be a witness against that person, the defendant?
Now that makes a lot of sense. Now let's put a change on that scenario. What if both parties are cited with a traffic offense causing the accident? What happens then?
Well, you have a criminal situation with the traffic citations, and then you also have the civil situation with your bodily injury claim. With the elements of negligence on the civil side, you have duty, breach, causation, and damages. The first thing to prove is duty. Everybody had a duty to drive safe. The next is who breached the duty. Well, if both parties got cited, they're saying you breached the duty, and they're saying you breached the duty somehow. Both of you have contested liability now. So both of you should go to court and have it resolved in the criminal court with the traffic citations first. You can still dispute the liability on the civil side because the burden of proof is lower on the civil side.
So how does the determination in court affect the personal injury claim? If I was in a collision and we were both cited, but I was found guilty and at fault, do I still have a personal injury claim?
You do. Everybody can file a claim, but it may not be a successful claim.
Okay, understood. Yeah. Attorney Davis, if you're ever at home during the day, you see tons of commercials from law firms and chiropractic offices. Tell us, how do insurance companies view your medical treatment with a chiropractor versus a medical doctor?
Insurance companies prefer medical doctors. I think they give them a little more credibility than chiropractic treatment. However, sometimes chiropractic treatment is more accessible to people, especially for those who don't have insurance, and the chiropractor will treat them on a lien basis, which means they'll take their settlement out of your settlement just so that you can get the treatment. But with not everyone having insurance to go to a primary care physician, you have to submit what you can. And again, keeping in mind the medical documentation, it's better than no medical documentation. But I believe they may take the medical doctor's records a little more seriously.
Lost wages are also a part of personal injury claims. If you missed work for any reason, for treatment or for the injury, you can seek to recoup that from the insurance companies. What is the advantage or disadvantage if you are unemployed? How can you claim the loss of the ability to look for work if you were injured as a result of a collision?
Lost wages are an item of special damages as opposed to general damages like pain and suffering. But special damages for lost wages, if you haven't lost wages, you don't have a claim for lost wages. But you may have a claim for lost capacity to earn. But you'll have to show, because you as the injured party still have the burden of proof by a preponderance of the evidence. That's just more likely than not this collision caused what you're claiming. So you'll have to show a track record that you were looking for employment, maybe you had an offer on the table, you had the collision, you couldn't show up, and now you've lost those wages. So speculation, it's a little hard sometimes, but it's possible to recover.
Well, Attorney Davis, thank you so much for joining us on Legally Speaking today. The first thing I want to do is run and check my insurance coverage amounts and see if I'm fully covered in the event of a collision.
Exactly.
Well, Attorney Davis, thank you so much for joining us today. We've learned a lot, and the first thing I want to do is go and check my insurance coverages.
That's right, that's right. And just to remind your viewers that my experience and my responses have been based upon having worked for an insurance company as well as working on the plaintiff side now.
So we've had the benefit of both sides of the coin, and now thank you so much for the information that you've given us.
Absolutely.
Next on Legally Speaking, we'll hear from medical malpractice attorney Woody Sampson. Stay with us.
Welcome back to Legally Speaking. I'm Sonia Brown. On today's show, we're discussing the topic of personal injury cases. Our next guest is attorney Woody Sampson, a partner at the law firm of Thomas, Kennedy, Sampson and Tompkins. Welcome to the show, Attorney Sampson.
Thank you, Sonia. Glad to be here.
I am very excited to have you here. And before we go into this topic a little more, why don't you tell our viewing audience a little bit about yourself and what it is that you do?
Well, I'm a native of Atlanta, Georgia. Went to Morehouse College and the University of Georgia Law School. About 18 years ago, I started practicing with my father, who started the firm of Thomas, Kennedy, Sampson, and what is now known as Tompkins. And we are the oldest African-American law firm in this state. We do litigation, a wide variety of litigation, from medical malpractice to personal injury to premises liability, and we do both sides. We do plaintiff's work, which is what it's called when we represent individuals. And we also represent Fortune 500 companies like the Coca-Cola Company, Nationwide, MARTA, and the Atlanta Housing Authority, just to name a few.
Well, I sound like we have the perfect guest. You can talk to us about it from both sides. And I want to get right into it because we hear about personal injury cases. I want to talk to you about medical malpractice specifically.
Certainly.
Now, we know a lot of times people, will have a misconception that if they or a loved one has suffered some sort of negligence at the hand of a medical provider, that they always have a claim. What are your thoughts on that?
Well, I see that all the time. And certainly when somebody, a loved one has been involved in a medical situation, it's usually a catastrophic event. It's either a catastrophic injury or death. And there are a lot of emotions that are taking place at that particular time. And usually when I get a call, I will counsel them on the law. The first question that I usually get from anybody that gives me a call is, do I have a case? And at that point, I don't know. I don't know whether or not the person has a case. There have been many times that I thought that a person had a case only to later find out that they do not have a case. And the reason is because I'm not a doctor. I'm not a doctor and I don't know the medicine. And really, in order to determine whether or not you have a medical malpractice claim in Georgia, I have to get an expert to take a look at the medical records of the situation that the loved one may have been involved in, as well as the past medical records, the medical treatment that took place preceding the particular incident. And usually what I'll do is I'll tell the person that calls to gather up all the records, bring them to me, and then I will send them out to a medical provider. Say, for instance, if you treated in the emergency room, I will find an emergency room doctor to take a look at the record to determine whether or not there's been what's called a breach of the standard of care. And you probably...
Can you tell our audience what the breach of a standard of care is? I mean, that's a lot of words. So what is that?
And it's sort of this nebulous, kind of vague term. But in essence, really, the standard of care is simply what would a reasonable physician do under like or similar circumstances when they're treating an individual. And doctors have, I guess, a certain minimum level of care that they're required to give in certain situations. And if they fall below that minimum level of care, then that's known as a breach of the standard of care. And no lawyer can tell you with a telephone call whether or not some doctor has breached the standard of care. Okay. So I counsel everyone that calls me. I tell them I don't know whether or not you have a case. I'll be happy to help investigate the case for you and to gather up all of your records. And then oftentimes, individuals will complain that they can't get records or they don't know what records to get. Okay. And I'll tell them that you are entitled to your records.
They're my records. So
they're your
as
records.
A patient, they're my records.
They're
so
your
they
records.
Can't be withheld.
They can't be withheld. Or if if they're dealing with a family member who has died, the administrator of the estate is entitled to those records, and those records you should be able to get. And you shouldn't get any pushback from any medical provider with respect to those records.
Well, let's say we've gotten the records, we've had the experts, we've determined that there is a viable case to move forward. What are the costs associated? How does someone, or how do you as a plaintiff's attorney determine what the costs are going to be for me as the person bringing this lawsuit?
Right, and that's a very good question because I get calls all the time from different individuals who think they may have a claim. And as I said before, I don't know whether or not the claim is going to be viable or not. I just have no way of knowing prior to getting an expert review. And so usually what I'll tell the clients that come to me is you will pay for the initial fee for obtaining the expert review. And usually that fee is somewhere, it can range from anywhere from $1,000 to $2,500. And that's one of the things about medical malpractice lawsuits is they can be very expensive. But if an expert says and comes back and says, there was a breach of the standard of care in that particular case, then I will take your case on what's known as a contingent fee basis. Okay. And I think that we talked a little bit in the first segment about that, and most personal injury attorneys take cases on a contingent fee basis. A lot of medical malpractice attorneys will charge a little higher percentage because the costs associated with bringing a medical malpractice case can be astronomical. Expenses can range from anywhere from $50,000 to $100,000 or more. I think the last—
You said expenses.
Expenses.
Right? Okay.
Expenses, meaning while I'm prosecuting the case, you don't have to pay any of that money. Okay. That $80,000 is what I would pay to prosecute the case,
so
to investigate.
You sort of advance us some money?
Well, it's not an advance.
Okay.
It's what happens during the course of the filing of the lawsuit, because several things have to happen. You have to hire an expert witness. That initial $2,500 just covers the initial expert review. That expert may become your testifying expert after that, at which point he will have probably more records to review as you